Okay, in this video, I wanted to go over civil procedure questions. There's actually 103 civil procedure questions. I just finished my first year of law school, and I wanted to share this with everybody. This is largely a quiz that I copied from one of the professors that he gave during the semester, and it was pretty helpful for just memorizing the terms and the different definitions for civil procedure. I'll copy and paste the link into the description for the quiz. It's on Google Classroom or Google Forms, I should say. And you got to put in a valid email address, and you can take it as many times as you want, and then it'll prompt you the right answer if you get it wrong. I won't be able to cover all 100 questions, but I'll try to get through most of it in the next 20 minutes or so. Okay, so first question, blank refers to the proper district in which to bring the action. It should be a convenient place to try the case based on the location, witnesses, and the evidence. And that, of course, refers to venue. So venue is the proper district to which to bring the action. For most of these terms, I would suggest you memorize them. So for me, what really worked well was to handwrite it, and then I made the quiz, and then I read them out loud, and then again, just handwriting it over and over is going to help you memorize and have a concrete and exact description of each term. For us, when we took our midterm and our final, he wanted us to write out he picked like 10 key terms, and he wanted us to write them out verbatim. So in order to get us to memorize, what these terms are. Okay, second question, Rule 48. Rule 48 refers to the size and unanimity of the jury. So Rule 48 is the size and the unanimity of the jury. Okay, next, the blank requires that in a diversity suit, the results should be the same in federal court as they would be in state court. So this is referred to as the outcome determinative test. So the outcome determinative test requires that diversity suits result in the same as in the federal court as they would in the state court. State long-arm statutes and the like provide a manner of giving notice to the defendants who are absent from the jurisdiction, allowing process to extend beyond the state's borders. So state armed statutes. All right, next, interrogatories under Rule 33. So Rule 33 is interrogatories, which are written questions submitted to a party which must be answered under oath. They are limited to parties to the suit. So that's important. Interrogatories only apply to parties who are in the suit. All right, Rule 45, when used with Rule 30, also called subpoena ducis tucum, is when a non-party can be deposed and required to bring documents and things with them to the deposition. So again, you combine Rule 45 with Rule 30, and you can depose someone and then also require them to bring documents. So Rule 45, just to get back on this one. So Rule 45 is there's a subpoena process. Rule 30 is deposition by an oral exam. It's an important one. Juries determine questions of fact, while judges determine questions of law. This may not be always the case, but the majority of the time that's correct. So the jury will determine questions of fact. Judges determine questions of law. Motion for judgment as a matter of, motion for a judgment as a matter of law. You need to know this term by heart. Motion for a judgment as a matter of law tests whether a reasonable jury, based on the evidence submitted, could find for the other side. So again, judgment as a matter of law tests whether a reasonable jury, based on the evidence submitted, could find for the other side. Discovery is a formal process in a civil suit where information is exchanged between parties. Too easy. All right, this is talking about class actions. In a class action, the named representative of the class must be capable of adequately representing the interests of all, and the named representative injury must be fairly and typically represent the injury that has been suffered. Okay. So there's 3 types of injunctions. So this one is a preliminary injunction may be issued after an initial hearing of some sort where both parties have the opportunity to present information. So there's preliminary, there's temporary, and permanent. Those are the 3 types of injunctions. Federal courts have subject matter jurisdiction of all civil actions arising under the Constitution of laws or treaties of the United States, regardless of, correct answer would be the amount in controversy. So federal courts have subject matter jurisdiction, and they don't have to satisfy the amount of controversy, which is $75,000 and a penny. So they don't need that because it's a federal question. All right. So this one is the 3 theories on which attorney fees to be recovered in class actions. So the 3 theories that attorneys can recover. One is common fund, substantial benefit, and private attorney general. I wouldn't really worry too much about that question. Diversity jurisdiction cases in federal courts. Federal courts have jurisdiction over the controversies involving state law if there is A, diversity of citizenship between the defendant and the plaintiff, and the claim is likely to exceed $75,000. So diversity action, you need 2 criteria. You need diversity of citizenship, and the claim needs to exceed $75,000. Okay, this is an important one. You need to know the elements of the minimum context test. What are the 4 key elements of the minimum context test under personal jurisdiction? Again, you should know this by heart. Meaningful and purposeful activity. It doesn't violate the traditional notions of fair play and substantial justice. 3, receive the benefits and protections of the forum state. And 4, systematic and continuous activity. And there's different ways you can kind of formulate the minimum context test, but in my mind and based on all the reading, these are the 4 ones that really are repeated in a lot of the case law. So again, the 4 are meaningful and purposeful activity, systematic and continuous activity. Doesn't violate the traditional notions of fair play and substantial justice, and the corporation received the benefit and protections of the forum state. Concurrent jurisdiction basically means that an action can be brought in both state and federal court. All right, this is an important one. What are the 4 exceptions of supplemental jurisdiction? Again, this term, supplemental jurisdiction, is important. So you need to know the 4 exceptions to supplemental. And that is, 1, the supplemental claim substantially predominates over the main claim. 2, the district court dismissed all claims over which it had original jurisdiction. 3, some other compelling reason formulated by the judge. Or 4, the state law issues are new or too complex. Okay. The due process clause requires a defendant to receive a notice and an opportunity to be heard prior to the award of any jury. So again, due process means that defendant has a chance to hear and has the chance to plead his case before any judgment is made against him. In the quiz, I did enter a couple of these long type of like narrative type questions. And these ones I got for a mini bar review that we had to take at the end of the first year. So I included some of those, not that many, maybe like a handful. All right, this one, next one. Blank is the power of the court to bind the defendant to any judgment it renders. Blank is waivable and can be conferred by consent of the defendant. The answer, of course, is personal jurisdiction. So personal jurisdiction is the power of the court to bind the defendant to any judgment it renders. This is a matching one for damages. I'll skip that one for now. Okay, permissive counterclaims arise from a different set of facts as the principal claim and therefore need a separate basis for jurisdiction. Permissive counterclaims arise from a different set of facts as the principal claim and therefore need a separate basis for jurisdiction. Rule 48 requires that a unanimous jury in reaching a verdict unless the parties agree otherwise. Rule 48, unanimous jury. What are the three standards of proof? This is an easy one. Three standards of proof are by the preponderance of the evidence, so that means 51% or more. Clear and convincing evidence. This is the civil side equivalent of beyond a reasonable doubt. And then three, you have the criminal side, which is beyond a reasonable doubt. Doesn't mean 99% or 100%, but probably more than 90. Same thing for clear and convincing. Doesn't mean 100%, but it means substantially more. Personal jurisdiction can be obtained by general or specific. Again, you need to know the different elements for general and the different elements for specific. So personal jurisdiction can be obtained by general or specific jurisdiction. The power of the court to hear controversies derives from the constitutional and various treaties. No, I got that one wrong. It's from the Constitution and various federal and state statutes. So this was like the best answer. They all kind of fit, but this is the best answer based on my professor, at least. The power of the court to hear controversies derives from the correct answer, Constitution and various federal and state statutes. All right, you need to know this. What are the three testing motions? Three testing motions are Rule 50, judgment as a matter of law. Rule 12, motion to dismiss. Rule 56, motion for summary judgment. And how you learn anything in law school is by creating mnemonics or acronyms. So I know that JML is judgment as a matter of law. MTD, motion to dismiss. MSJ, motion for summary judgment. Then again, you want indicators or triggers that are going to able to trigger that thought or that definition in your mind. The court must have the jurisdiction to hear the case for any judgment it renders or any judgment it renders void. All right, so I'll say that again. The court must have jurisdiction to hear the case or any judgment it renders is void. That makes sense. All right, what is a material fact? A material fact is a fact of consequence to the lawsuit. Material fact is a fact of consequence to the lawsuit. All right, Rule 4. Rule 4, it provides the mechanics for effectuating service of process which is consistent with the requirements of the due process clause. So Rule 4 is due process. All right, in federal court, the test for venue considers where the cause of action arose and where the defendant resides. A corporation resides wherever it has established the minimum contacts. So this is a bit confusing. So there are two tests for venue. There's the federal court test, and then there's the state court test. So I have a question for each in this quiz. So try to memorize or know the difference between federal and the state court test for venue. All right, removal jurisdiction, another one that you need to know. Removal jurisdiction provides, removal jurisdiction provides the defendant the right to remove any action from state court to federal court if the action could have otherwise been brought in federal court, unless, keynote here, unless the basis for removal is diversity, and in that case, the defendant cannot be from that same state. The defendant must answer the complaint in a clear and concise manner, either admitting or denying the allegations in the complaint. All right, preponderance of the evidence, we already mentioned, is a general civil standard that requires a complaint to tip the scale ever so slightly in its favor. All you need to show is that it is more likely true than not. All right, we'll skip estoppel. All right, Rule 35. Rule 35 is a request for a physical or mental exam. It can be filed if the physical or mental condition of a party is an issue in the case, but it is limited to the party or the agent of a party. All right, summary judgment, another one you need to memorize. Summary judgment tests the sufficiency of the pleadings taken as a whole to see if there are any material facts in dispute. So summary judgment, the testing motion to see if there are any material facts in dispute. If there aren't, then it's asking the judge to make a decision on the case. All right. Let's see. Rule 8.2. Rule 8A2. Excuse me. Rule 8 Alpha 2. That's a federal rule of procedure, requires a short and plain statements of the claim showing that the pleader is entitled to relief. So Rule 8 Alpha 2 requires short and plain statements of the claim showing that the pleader is entitled to relief. In the complaint, you should state the facts in a clear and concise manner. Okay. Permanent injunction is issued only after a full hearing of the merits of the case and remains in force unless reversed on appeal. So permanent injunction is only issued after a full hearing. Notice pleading. Notice pleading only requires you to put the other side on notice as to what has happened, enough to establish a prima facie case that there has been a violation of the law and your client's rights have been affected by that violation. In other words, you just need the bare minimum. You don't need to plead everything. You just need to have enough to survive a summary judgment. The scope of discovery is found in Rule 26. So 26 is the scope of discovery, which says that you may obtain information from the other side which is relevant to the lawsuit or which could lead to relevant information and is not otherwise privileged. All right. Supplemental jurisdiction, again, you need to know this one, provides jurisdiction over the claims that arise from the same set of operative facts as the principal claim asserted in federal court. I'll say that again. Supplemental jurisdiction provides jurisdiction over the claims that arise from the same set of operative facts as the principal claim. Rule 37, sanctions. Sanctions are imposed on the defendant for failure to cooperate in discovery and preclude that party from contesting certain issues. All right. Rule 36 is request for admissions, which require a party to admit or deny certain statements of fact. All right. Rule 34 is production of documents and things. So Rule 34 require a party to produce relevant documents or things upon a proper request. Okay, injunctive relief is granted at the let's see here. Sorry, injunctive relief is granted at the blank of the court, at the discretion of the court. Since injunctive relief is an equitable measure, it is granted or denied by a judge without the aid of a jury, based on the 5-part test. So, right. So injunctive relief, again, it's at the discretion of the court, and it is done without the aid of a jury. It's by the judge only. Class action is where a large group of people have been injured as a result of common questions of law or fact, such that they can collectively sue to obtain relief. All right, Rule 8C, 8 Charlie, requires affirmative defenses to be pled by the defendant or they are waived. All right, subject matter jurisdiction. Again, you need to know this definition. Subject matter jurisdiction is the power of the court over the controversy. Without it, any judgment that the court renders is void. All right, I'm skipping around here. All right, in a civil case, it is the plaintiff's burden to show both liability and damages. Makes sense? All right, damages are designed to make the plaintiff whole. Damages awards are designed to put the plaintiff in the position it would have been but for the defendant's action. I would actually write down this definition. I think it's a pretty good one. Again, damages are designed to make the plaintiff whole. Damages awards are designed to put the plaintiff in the position it would have been but for the defendant's actions. Summary judgment applies when there are no material facts in dispute that rise to a triable level and the judge determines how the law resolves the case. Again, another good definition. Compulsory counterclaims. Compulsory counterclaims arise from the same common nucleus of operative facts. So my mnemonic for this is CONOP, common nucleus of operative facts, as the principal claim, so that there is no need for a separate basis for jurisdiction. Latches means that the plaintiff has delayed asserting his rights, which has caused prejudice to the other side. So latches is causing an unreasonable delay. An individual who is personally served within the state with process is subject to that state's court exercise of in personam jurisdiction. Corporations are citizens of both their state of incorporation and principal place of business. Rule 15 states the pleadings can be amended and leave to amend should be freely given. So Rule 15 allows for amended pleadings. All right. In state court, it's another good definition. In state court, the test for venue considers the location of the plaintiff, the location of the defendant, and the forum where the cause of action arose. All right. Motion for summary judgment. Test the sufficiency of the pleadings taken as a whole to determine if there are material facts in dispute that rise to a triable level. All right, Rule 37. Again, Rule 37 is sanctions. So Rule 37 can include fines for delaying discovery, preclusion from contesting certain issues, preclusion from producing information, and can include judgment against the disobeying party. All right, Rule 12G encourages the consolidation of various defenses in a single motion to dismiss. So Rule 12G just consolidates defenses. All right, skip that one. Rule 12B6 is a failure to state a claim upon relief can be granted. So again, I'd write this one down maybe 20 times. You need to memorize this. Rule 12b-6 is the failure to state a claim upon which relief can be granted. All right, Rule 51 deals with jury instructions. Rule 51 is jury instructions. All right, service of process. The service of process standard requires that that notice be reasonably calculated under the circumstances to apprise the defendant as to what is going on. Again, this is consistent with the due process clause. All right, indispensable party. All parties must be named or the case can be dismissed for failure to join an indispensable party. So if a party is indispensable, then they have to be properly named on the lawsuit. All right, what are the 5 elements? So what's the 5-part test for injunctive relief? That's another way to formulate this question. The 5-part test is there an adequate remedy at law? Is there an immediate and irreparable injury? That's the mnemonic there. Balance of harms, public policy concerns, and likelihood to succeed on the merits. So that's the 5-part test. Again, something else, another one that you really need to commit to memory. Venue should be where a substantial part of the events giving rise to the cause of action occurred. Probably the best definition of venue that I've heard. Depositions, Rule 30 is the most common form of discovery. Attorneys examine and cross-examine the witness whose testimony is preserved by audio, video, or stenography. All right, the only time the outcome determinative test can be violated in resolving diversity suits is when there is a federal rule directly on point or where an important federal right is at stake, such as the right to a jury trial. And you should have read a case that dealt with this issue on point. What must always be established in order to enter a suit? Easy one. You need SPV, and that is subject matter jurisdiction, personal jurisdiction, and venue. Choice of law issues arise, particularly when a case is being tried in federal court. That's right, because sometimes you have to decide what state law you need to use. Rule 30 applies to parties and witnesses. Skip that. Oh, I got this one wrong. I don't know how I got this one. Interpleader. Interpleader is when a stakeholder is holding funds or something to which there are multiple claims or potential claimants. The plaintiff may file an interpleader to have the court determine the rights of those claimants. An interpleader provides the plaintiff with assurance that it will not be exposed to multiple liability. So that's interpleader. Impleader is something different. And we can look that up real quick. Right, so impleader is when you join a third party to the lawsuit. So try to know that you need to memorize the difference between those. Interpleader is when you're holding money and you don't know who to give the money to, so you file an interpleader. An impleader is when you're trying to bring a third party, an outside third party, to the lawsuit. Motion for summary judgment, motion to dismiss, test the sufficiency of the complaint. Rule 11, probably need to know this just as a good attorney or future attorney. Rule 11 describes a good faith requirement of all attorneys who sign pleadings. In every pleading, the attorney certifies that he has read it, understands it, made an investigation, is based on existing law, or a good faith belief in reversing or existing the law that is not interposed for any purpose such as delay or harassment. And you should have read a case where the attorney didn't have any experience in this particular field of the law, and he didn't know what he was doing. I think it was over a patent issue, and he had ended up just not knowing the law very well and botched the case for his client. So again, little things that you need to know. Personal jurisdiction is obtained by establishing the defendant's minimum contacts within the jurisdiction, such as the court's exercise of jurisdiction is reasonable. Again, minimum contacts. Personal jurisdiction is obtained by establishing the defendant's minimum contacts within the jurisdiction, such as the court's exercise of jurisdiction is reasonable. Rule 12b-6 again. Test the sufficiency of the complaint and ask the court to dismiss the action for failing to state a case or for failure to state a cause of action upon which relief can be granted. All right, just 3 more minutes. The complaint should contain statements of fact and not conclusions of law. Skip that. Oh, and that's it. We're done. So again, I will post the link in the description. Any comments or feedback is obviously welcome. Anything else you would like to see, please let me know. Thank you.